Well, Capitec is finding itself in a spot of bother, and it's all related to its so-called multi-loans. The company's alleged refusal to supply contracts and other related documents when requested to do so by clients doesn't seem to be playing fair. This is the MoneyMakers. I'm Bruce Whitfield. I'm joined by Clark Gardner, Chief Executive of Summit Financial Partners. They are taking Capitec to court for allegedly breaking the National Credit Act. Isn't that the job of the National Credit Regulator, Clark? You can look at me, it's all right. We're in the same place. Isn't it the job of the National Credit Regulator to take people to court for breaches of the National Credit Act?
It is, most certainly, and the truth is they have. They've taken Capitec and referred them to the National Consumer Tribunal. Unfortunately, the National Consumer Tribunal ruled against them on a technicality, saying that they were a bit on a witch hunt and they have to have good cause to raise a complaint and refer. And so the merits of this case never came to book.
Okay, so what is the allegation that has been put against Capitec? Because it's quite complicated stuff, this.
It is complicated. So the National Credit Act is quite specific around reckless lending. And the product that we are now taking to court is the multi-loan.
And this is a Capitec product called multi-loan.
Correct,
right?
And I haven't seen anything similar in the market. And we are alleging that they are reckless in issuing these loans for the simple reason that they don't adhere to Section 81 of the National Credit Act, not to get too technical. So the reason we're saying that is Capitec provides you with a loan, a contract, a credit agreement, and that credit agreement allows you 12 payday loans effectively in the next year. Our concern is that when you access the multi-loans after the first month, you can do it via an ATM withdrawal. So you simply put in your card, put your PIN in, and you get your new loan.
So you have to go through an administrative process up front. They then pre-approve 12 of these loans concurrently, subsequently, and you don't need to engage in any kind of future administrative process. So 6 months' time, you've lost your job, you have had 3 funerals in the family, you're on the bones of your backside. Thank goodness you've got the multi-loan, because that's keeping you out of trouble for now. Is that the sort of scenario we're looking at?
Look, our view, it puts you in trouble, so that's just
Correct.
Your last comment. But it is correct. So what happens is on the ATM, you get 3 questions. Has your circumstances changed? Has your income?
No.
Exactly.
No.
You're desperate.
Yep.
You need the money, so you answer it.
Which then legally, you might not necessarily appreciate the legal consequences because you're lying to a legal questionnaire.
Correct. And you know, part of the National Credit Act is to protect their consumers from their own ignorance or desperation. And as a result, the law actually states that the job of the credit provider is to make sure you understand the obligation, risks, and costs associated with the agreement at the time of that credit agreement.
But the time the credit agreement was agreed to today, I got into trouble 9 months from now. I kind of forgotten the conversation that happened 9 months ago, haven't I?
And that's why we're saying it's reckless lending. So if you haven't had that conversation with the client, if you haven't made sure they understand the costs, risks, and obligations related to that agreement, it is reckless.
Is it reasonable, though, to expect Capitec to engage every single month before somebody takes out the multi-loan on the terms and conditions of the contract? Because that would add a layer of cost and theoretically make the product even more expensive.
I would take a step backwards before I answer that, and that is to say that we have 10 million credit active consumers with impaired records in this country. And so the lending industry, the unsecured lending industry, which is relatively immature, 94 it started, 2007 it flourished as a result of a badly written National Credit Act. And now we sit with 10 million people that are financially disempowered. They cannot access a mortgage, they cannot access business loans or vehicle loans, etc. And we believe the problem lies with payday lending. Payday lending is the month-to-month loan. So if I take a loan on the 15th, I've got to pay it back on my payday, which is the 25th, which is what the multi-loan does in 12 installments. Now, if you're saying, shouldn't we reduce the cost to issue these are reduced. There's no cost for Capitec from the 2nd to the 12th to issue and advance these loans. And they have very low default rates on that. They vary from 9 to 12%.
Which in micro-lending terms is very low, which suggests then that they are getting their risk right.
Correct, but not payday loans are ordinarily very, very low default rates. They're the best performers because you're incentivized to pay back because the next month you get your new loan.
Yes.
And what happens ordinarily, many of these roll those loans. It's a debt spiral. So you want to pay off that loan first, thereby risking your mortgage and your term loans that are much cheaper because you've got to pay this multi-loan. Our concern is that Capitec is charging an upfront initiation fee of 12% flat rate on these loans.
Okay, so I borrow 1,000 rand. They charge me 120 bucks to borrow the 1,000 rand. Okay,
Correct. Even if that's now your sixth draw, you go to your ATM, you draw your 5,000 rand. If you draw it on the 15th, on the 25th, you'll pay 5,800 rand back.
but that's over a lot of interest over a short period of time.
It's because it's not interest, it's initiation fee.
It's
a fixed fee.
Yeah, okay.
It's not a function of time. And that makes it 400% per annum, which we're saying on a 9% default rate with no costs associated with administration, that sounds like excess to me.
Now, a Capitec's argument is that either you are too dumb to understand what's going on, they're too polite to say that, they don't want to pick a fight unnecessarily, but they're saying you're disagreeing on a technical matter. They haven't specified on their side what that technical matter is. You're calling it a 400% interest rate, they're calling it an initiation fee. They're fundamentally different things. And in terms of the NCA, they're entitled to charge that initiation fee.
They are entitled on every new agreement to charge that upfront initiation fee.
And isn't every agreement, a new agreement over 12 months, a new agreement?
I don't see a credit agreement when I withdraw that cash from the ATM. I don't see the conversation around.
They've asked me 3 questions. They've said,
Yes.
have my circumstances changed? I mean, does that not legally, it may not be morally, but could legally constitute, clearly they've got legal advice that says that therefore entitles them to do so. That is a credit agreement.
So I suppose, I don't believe they think that's a credit agreement because it's not.
Okay.
A credit agreement must be in writing.
Okay,
Okay. Secondly, they're determining that that's an affordability assessment.
fair enough.
And that's
yeah.
actually where they're saying it's a technical matter. And we're saying in order to be an affordability assessment, we've got to look at the De Beers ABSA case in December, where they said, well, hang on, you can't take the consumer's word for it. Where's the source documents? Have you checked their income and their payslip and their bank statements? And post 13 September, we know that the regulations changed and said you must get 3 months bank statements, you must get 3 months payslips to substantiate the income that you're assuming this person has, as well as their living costs, as well as their credit records. Now that can't be done real time via an ATM. More importantly, did you make sure that consumer understood the risk, costs, and obligations? Now, if you think you've drawn your 5,000 rand on the 15th, on the 25th, did you know you have to pay back 5,800? How do you know? You haven't got a credit agreement. You haven't had a conversation.
But haven't you had that initial credit agreement up front? Haven't they done that paperwork in the initial consultation?
That's for the first agreement, in my view. So they've done that. That's for the first agreement. If you want to do it as a facility, like you and I might have a credit facility, that's fine. You draw up to 5,000 and you're not charged the 12% up front. You charge the 22%.
But they're charging the 12% for each
every
withdrawal.
single withdrawal.
Now, that seems a little rough.
Well, I think so. I think it's bad for society. It's bad for the lending industry. It's putting the other good loans at risk because they're stealing the wallet wall. And it really sounds like excess. If you look at their records, 3.2 million of their 3.7 million loans advanced in the past financial year were short-term in nature.
No, short-term, but is that the same then as these payday loans? Because short-term is a 3-month loan or a 6-month loan.
It could be. We've chatted to them and they don't give that breakdown. We think the majority would be the multi-loan.
Okay.
So if you have a look at our biggest client in Platinum, mine in Rustenburg, 10,000 clients received 150,000 multi-loans. And we're just saying, hang on, that's an average of 15 loans.
Yeah.
Why don't you rather give this employee one term loan or a 12-month loan? Because then you're only charging 40% per annum.
Now, they're not talking about this. What response do they give you when you ask those kind of questions?
No, they don't respond to us. They did in December last year, they provided a response of a technical nature purely on process, not on the merits of the case. So they were saying our power of attorneys were not legal and not valid. They never argued that we're saying this is reckless, you shouldn't be charging the initiation fee, or you should be doing an affordability assessment on each drawdown, or give a new contract, or provide the pre-agreement quote that is required by the National Credit Act on all short-term loans.
How serious is Capitec's exposure here?
Well, they advanced 7.7 billion rand in short-term loans in the past financial year. They earned about 1.2 billion rand on that type of loan. If a loan is declared reckless, as in the De Beers ABSA case, they actually wrote off the full amount, and that was mortgage.
Yeah.
So that 7.7 billion rand could be null and void, and you lose all your risk and obligations.
But you're making the assumption that the 7.7 billion is all of these multi-loans, which it can't be, which is unlikely to be.
Okay, let's say 50% of that.
Okay, but we're guessing.
Yes.
Okay, so the potential liability, 3 billion rands worth of write-offs that they might have to take on this. Their argument is this is of a technical nature. That seems like quite a clever holding statement on their part. I mean, clearly the big guns will come out in court when you face them.
No, they definitely will. I even doubt they would discuss the merits or try and debate the merits. They're going to try and find a reason around that.
But as with the National Credit Regulator, there was a technical reason for the technical reason not being accepted.
Correct. They were saying the NCR was on a fishing expedition. They must have good cause to fight this, and they got Wim Trent-Grove to represent them at the tribunal. And the tribunal, very unfortunately, ruled against the regulator. And I think the High Court found the same when they took it on appeal. So yes, the regulator's out of the game, so that brings in Summit again. So let's see what we can do.
Okay, so what is, without showing all the cards, but what is the game plan here?
The game plan is that there's one case that we're testing at the moment to declare this multi-loan reckless.
And what gives you the authority to act on behalf of this one case? You haven't borrowed the money, so why should you get involved?
No, we have access to our employers pay Summit to look after the employees' financial health. As a result, we get 3,000-4,000 cases a month where people say, please help me, I'm over indebted. And by definition, if someone's over indebted, there was someone who was reckless. And usually it's Capitec or one of the unsecured lenders, but certainly the multi-loan comes up on our radar the most. And we say, well, hang on, sign this power of attorney and we'll fight the recklessness of this case in court and either try get it written off or at least suspended until your other debts are paid. So we've taken one loan, and then we'll certainly move on to declare a class and take on a much bigger case once we've understood and learnt from our previous cases.
Now, what is the time frame on this? Because the South African court system is nothing but glacial. In most circumstances, this could drag out for years.
It could, most certainly. And there's no way around that. We can apply for urgency, we can do all sorts of things, but we don't have a great case for that.
But let's say this takes 2 years to come to fruition. The multi-loan continues as it does for the time being, with massive upfront fees for every loan that is granted. 5,000 rand seems a bit rich every month for many of Capitec's clients, but let's say it's 1,000 rand per client who goes into the multi-loan facility. That's 120 bucks every single month. That's a couple of grand every single year in fees per customer. That's pretty profitable business. They can afford to hold you off for quite a long time.
No, certainly. I think this multi-loan is worth around about R1 billion a year in the last 7 years in terms of fees. To their credit, they stopped the multi-loan in November 2015.
Okay.
So we're actually looking for redress to those consumers who overpaid because they were paying on a monthly.
Is that an admission of guilt on their part?
I don't think so. I think
if it's such good business, why would you discontinue it?
As I understand it, their excuse or their reasoning is that there's new regulations from September 2015, I think it was the 14th of September, where the regulator came up with new regulations that in order to do an affordability assessment, you must get 3 months bank statements or 3 months pay slips. And they're saying, well, hang on, that's a good reason to get rid of the multi-loan.
Clark Gardner, we'll leave it there. But thanks very much for coming in this evening. Capitec, if you're listening, we'd love to chat to you at some point. Clark Gardner is the Chief Executive of Summit Financial Partners. More cases of economic justice going wrong into the future. But for now, though, thank you so much for watching. Good evening.